Convicted Prisoners Amendment Bill first reading.
Mr. Speaker.
I call Paul Quinn.
Thank you, Mr. Speaker. I move that the Electoral Disqualification of Convicted Prisoners Amendment Bill be now read a first time. Mr. Speaker, at the appropriate time, I intend to move that this bill be considered by the Law and Order Select Committee. This bill comes before this House because of a large number of ordinary folk who have asked me and discussed this matter and believe that this should be the case. And I have to say that since it has become public knowledge, that the level of support in fact has been overwhelming. And I think that that speaks volumes for the mood of the community and in fact getting behind this bill. In saying that, I have to acknowledge there has been some muffled criticisms, but most of that in fact has come from prisoner aid type organisations, and I'm sure should I be fortunate enough to have this bill go to the Select Committee, that they will have the opportunity to make their presentations then. I think at this stage it's quite useful to canvass the history of this, where we are today with this particular bill, and historically the vote of prisoners, the idea of voting was considered a privilege. But as we have moved through the 20th century, we have of course moved to a situation where voting has become a right. Now, up until 1975, the law was that any person detained in prison, a penal institution pursuant to a conviction, was disqualified from voting. In 1975 that was changed, and for a period of 2 years the law enabled some prisoners to be able to vote. But in 1977 the law was repealed and we went back to the old situation where in fact prisoners could not vote. Now I think it's important to just pause for a moment and reflect on the concept of imprisonment and what that's about. And imprisonment was looked on as a temporary exclusion of a person from the community and the rights associated with membership towards that community, within that community. And I think the nux of this discussion and this conversation is around that very thought. In the 1986 report of the Royal Commission on the electoral system proffered a different view with the somewhat simplified statement that contemporary penal theory is generally opposed to the view that imprisonment entails a suspension of rights of citizenship, unquote. This view was based on the 1981 report of the Penal Policy Review Committee, which noted the fundamental principle related to a prisoner's rights, quote, must be that a prisoner retains the ordinary rights of a citizen insofar as they are consistent with his loss of liberty and the requirements necessary for his proper containment and management in the institution. In my view, the Royal Commission demolished its own this academic notion by then wanting to demonstrate the point by saying that a prisoner is entitled to be married. What it didn't say, of course, is that when a prisoner goes into prison, he loses his conjugal rights. The truth is, almost all our laws impose a restriction to a greater or lesser extent on our freedoms. And the right of, a classic association here is the right to freedom of association. We have a law. Which says, which in fact can convict people for unlawful assembly. And how does unlawful assembly define? Unlawful assembly is defined as an assembly of 3 or more persons who, with intent to carry out a common purpose, assemble in such a manner or so conduct themselves when assembled as to cause persons in the neighbourhood to fear on reasonable grounds. Now, the fact of the matter is that one person's fear is another person's pleasure. But society has made a conscious decision to say that, in fact, we believe there should be some restrictions around freedom of association. There are many other examples where we restrict people's rights. We in fact require people to in fact license dogs. Where's the here we have another restriction on people's freedom. Fortunately, the Royal Commission did acknowledge the punishment at some stage reaches such a serious nature that the community does have a right to object. And that they then said, well, there's a line here at which point we believe if you cross, then you should lose your votes. And then they said, well, what's a reasonable period? And you know what they did? They said, well, if you go overseas for more than 3 years, you lose your right to vote. So we think that's about a good benchmark. So that's the reason it's 3 years, because someone has exercised their own right and privilege to go overseas for more than 3 years, they lose their vote, and that's what they benchmark the prisoner's right in. And I say that's a nonsense, an absolute nonsense, where someone has exercised their freedom of choice as opposed to someone that has committed a crime against the community. And sadly, in my view, it reflects the lack of understanding of grassroots feeling around the academic notions that people that make these decisions feel. So I just I should just canvass briefly the view of the Solicitor General who canvassed this issue in respect to the Bill of Rights, and he in fact supported the same position as the Royal Commission, which was to actually support the Royal Commission that in fact at a point of 3 years... I
regret to interrupt the member, but the time